I understand this need to look at even perhaps a national scheme around this, about how even police in different states might talk more openly with each other about perpetrators, to be able to give an additional level of comfort to women in particular around potential future partners.
You've shown no remorse or apologised for her death.
Killer narcissists.
He was the last person to see her after they had an argument at their family home.
We had a bit of an argument in regards to the store figures.
He kept tripping up because he thought he was invincible.
Expert abusers.
Very deliberate manipulation to make her think that she's nuts.
The same strategies.
He used to call her princess.
The same traits.
A grandiosity, an entitlement, a lack of empathy.
And it's never their fault.
Mental illness called her death, not me.
As incidents rise,
More women are being murdered by their partners than ever before.
Yeah, you disposed of her in an undignified way.
And sentences don't.
Women as victims have such low status, even when they lose their lives.
They are dangerous and they will remain dangerous.
We investigate why,
dumping her over a ledge to leave her lying in mud,
these criminals continue.
Boris, did you kill Karen?
To be underestimated.
I've got nothing to say to you.
Introducing Kiss and Kill. Episode 9. Risky Business. I'm Alison Sandy.
A time clock is used to record the time of arrival and departure of each employee.
A flashback to a news story on the modern office.
Mail is placed in the in tray on each officer's desk, ready for reply or other action.
A time when women were mostly assistants and men were boss.
Typists transcribe from dictation equipment through modern lightweight headphones.
Undoubtedly, since then, there's been significant change for the better.
The routine work in the office.
But at a cost.
The whole system is problematic. And, the system wasn't designed and wasn't created to protect women and children. And it is very much stacked in favour of the perpetrator.
Yet to be addressed.
And that comes down to the broader picture of patriarchy, misogyny, sexism, chauvinism. These are all culturally embedded things in all of us that you have to tackle. And that's why Tyrone Thompson was bailed all the time. Why give an AVO? And I always say this to professionals, don't bother getting a protection order if you're not going to follow up on breaches. Because all you're doing is giving someone a false sense of security. And again, it just comes down to whose life is valued more.
So what will it take to make sure the legal system is representative of modern values? Internationally renowned forensic criminologist Laura Richards, formerly of New Scotland Yard and host of the landmark podcast, Crime Analyst.
We see platitudes, we see marches, anger, we see various politicians being rolled out, talking the rhetoric, but still no change. And that's where we need something far more robust, the whole system to be overhauled and to be looked at to ensure that each part of it is fit for purpose. And that's a huge undertaking because I'm talking about the criminal legal system. I'm talking about the family courts, the civil courts, the criminal courts, and almost starting again of what does justice look like? When I'm watching the trial and the sentencing of Tyrone Thompson and I hear a judge refer to the victim as the deceased rather than using her name.
The decision is yet another reminder that in Australia, women's lives are not valued.
I want to scream because he is dehumanising her every time he's saying the deceased and he's calling Tyrone Thompson Mr. Thompson. He's giving him respect in the way he's addressing him, and he's being dehumanising to Mackenzie and to her family. These are easy fixes in some respect, but they're things that have to be attended to, because that's why victims' families feel like they're constantly the poor relative, that they're not being heard, they're not being listened to, they're the ones having to make the adjustments all the time, whereas he's being called Mr. Thompson, and he says one thing that the judge takes into account that is remorse. I didn't see what Tyrone Thompson said as remorse. And we call it the criminal justice system. The criminal justice system, because it favours the criminal.
One of the arguments that has been put to me is that they would rather 9 guilty men go free than 1 innocent man go to prison. Do you think there is a danger then that if we change the system that it wouldn't be a case of innocent people going to jail?
I think they're two different things, actually. And having worked in the police, you know, we make risk assessments all the time of who's risky, who's dangerous. And at the point that you've arrested someone and you put them before the court, you look at their criminal history. And let's take Tyrone Thompson. Multiple assaults on Mackenzie, physical evidence. So there's photographs of the bruising, the things that he did. There's a history of an attempted murder. When you join up his history and we're doing the risk assessment, we can see that he's a problem. So that risk assessment gets put to the court. That is a routine thing to do. And arguments are made every day about whether someone should be bailed or remanded. You've got a remand for a reason. Australia has a big problem because you keep bailing dangerous men. And I'm talking about there's a cohort of coercive controllers and stalkers. They're actually a smaller number. The risk assessment is missing the risk that they are. Kelly Wilkinson is another example.
Over 23 days, the mother had frequent contact with the QPS. After initially raising fears about her estranged husband's behaviour, she was given a protection order, later flagged as a high-risk aggrieved. That was upgraded, restricting Johnston's contact with her and the children. Kelly reported a breach at Southport Police Station. The officer thought she was cop shopping to get the outcome she wanted. The same day, Brian Johnston was charged with raping Kelly. The CIB detective wrongly gave him police bail. The allegations were so serious he needed to show cause to a magistrate. 9 days later, Kelly was killed.
And these cases I've examined myself because they are abject failures of risk assessment. And police do this every day. You don't put a terrorist before the court and say, oh, but we're going to bail him. Yeah, he's building a bomb, but you know what? His right to freedom. We don't want him to go to jail because he's innocent till proven guilty, right? No one ever says that. And I want domestic abusers and stalkers to be treated just as seriously as terrorists because that's what they are. And they have proven histories. Most of these men have proven histories. You do get the ones like Boris Rostevsky, Jared Baden-Clay. We've had a number of those cases in the UK, in the US. No history that we know of. But these men can control just by the look, the thing that they say, they are actually more dangerous. That's why it's so critical. And it's the risk assessments that are flawed. So it's not about innocent until proven guilty. It's about risk assessing. So that's why I created a dash risk assessment in the UK. You know, you've now got the homicide timeline that can be used, although you can't just assess people through murder alone, through the prism of murder, for all the reasons that I'm talking to. That you have to look at every part of their behavioural patterning in terms of every partner that they've had, you know, looking, are they a serial perpetrator? And it's the prosecution's job to argue that to the court, that based on the evidence and the facts, he is a high risk of harm to the victim, and therefore we are asking for him to be remanded. But I'm not hearing enough of those arguments being made, and they should be made, and it's quite right that they are made.
But I guess there is this opinion that these sorts of killers aren't dangerous.
Yeah, but then you've got another problem right there, that there was a plea deal, and so he gets manslaughter.
Laura is referring to Boris Rostevsky.
You know, it turned on its head at the 11th hour, and I tracked it because I talked about it when it happened. The fact that he could maintain a web of lies for almost 3 years, that takes a certain person to be able to do that. Someone who's used to lying to his nearest and dearest, to retain the relationship with his daughter, Sarah. And at the 11th hour, he pleads guilty to manslaughter to make the murder trial go away. And I've heard various stories about that it was his son who said he was going to expose him and say things at the murder trial. And that's why suddenly you've got this plea deal at the 11th hour. But I think men like Rostevsky, there shouldn't be a plea deal. I think there are certain cases where you can change the law so that it's not appropriate to plea it down to something lesser when someone is so dangerous and so diabolical. And I suspect if they assess him for psychopathy, he's a psychopath. And again, that's another part of the system that I feel is failing, that we now have even more accurate research. And I don't know whether you have found Dr. Karen Mitchell's research as you've been doing your research. We've had the psychopathy checklist, which was created by Dr. Robert Hare, which has its merit, but there is not one characteristic in there that talks to power and control, that their drive is to dominate. So it misses the key driving characteristic for their behaviour. But if you look at the 20 attributes that Dr. Karen Mitchell has discovered through her research, 2024, she created a new framework of a persistent predatory personality.
According to the website, this is the most comprehensive study ever undertaken into dark personalities, including narcissism, psychopathy, Machiavellianism, coercive control, and toxic leadership. I will seek to interview Dr. Mitchell in the future.
I favour it because A, you can indirectly assess people, which you should indirectly assess them. Too many assessments rely solely on what the offender is telling the risk assessor. Well, we know that these individuals are pathological liars, so you cannot just assess them on direct report.
Laura refers to a point made by Dr. Russ Scott in episode 2 about it being necessary to make an indirect assessment of these types of people due to their ability to present in whatever guise will help them get what they want.
You have to assess from other people who know them best. But Dr. Mitchell's work shows that they're persistent, i.e., you can't treat them. You can't cure them. You cannot rehabilitate them. So the men we're talking about, the 3 that I've named today that you've looked at in depth and talked to the people that they've impacted, they would score high on the persistent predatory personality attributes. In fact, looking at it, they've ticked every box. And anybody who thinks that a dark personality, a psychopath, a persistent predatory personality can be rehabilitated, they do not understand their tradecraft. It's not actually about just their social interactions. It's that their brains are different. And they don't have empathy and remorse. They are fearlessly dominant. They are brazen in what they do. They don't emote in the same way as the rest of us. So they don't have this cognitive load of morals, ethics, values holding them back. So they are overly confident, but they are very sadistic and cruel and diabolical, and they have this callous disregard for human life. And I think the paper, the 2 doctors that you spoke to, Dr. Scott and Dr. Freckleton, the narcissistic rage paper back in 2018, it gave us a new understanding to a degree. But it's the fact these individuals, their brains are different, they can't be treated, they can't be rehabilitated. So why do we keep giving them lesser sentences? Why are we releasing them? And mostly we're releasing them early.
This is a very pertinent point. So what do we know about the possible release of Baden, Clay and Rostevsky? Both are eligible for parole next year and have the following in common. Neither had a violent record. They tried to cover up their crimes and won't admit to what happened, and appear much more concerned for their own situation than that of their victims. I say victims because it's not just the person they killed, but the others left behind.
I've been doing a lot of work in the UK to keep very dangerous men locked up. So I understand this area very well. Even though I'm not the one doing the assessments, I am an expert on the Home Office's roundtable for stalkers, and I'm the person saying that there's a lack of training for the professionals. They come to me for me to help them, understand because they realise that these guys are different. But how does that impact their risk assessment and what does that mean for risk management? And too often they're being released and then you get the next victim and the next victim. So I think it's something that absolutely needs to be looked at that end of the criminal legal system.
Well, I think that's what we can see with all of these, because we do the 6 as well. We got the other 3 are Louis Marnie, Charles Evans and Anthony Erickson. And the thing that they all have in common, I guess the coercive control is one aspect of it, but also their lack of remorse, also their lack of care, consideration and acknowledgement of fault in their own behaviour. That is, and I find that incredible. So I gather that's a sort of killer or the perpetrator that you're talking about.
Absolutely. And they genuinely have no remorse at all. They don't feel it. They can mimic it if they have to. So they are chameleon-esque. And that's one of the traits, to be a chameleon, to watch, to see. They're very good at gauging emotional temperature, but they don't feel genuine empathy. They can't put themselves in someone else's shoes. They are very self-serving. And that's all they do is self-serve, image protect. So we have to understand that that's what they're doing. And they have this unwillingness to accept any responsibility. So even with Tyrone Thompson and Mackenzie, you think, wow, he's caught with the knife. There's really nowhere for him to go because the police arrive and there he is covered in blood. But he makes a number of conscious utterances to insinuate that it was her that attacked him. Even with the letter he wrote, that it was still, well, she brought this upon herself. A dead victim, stabbed 78 times, and the baby was there, and he has no shame, no remorse about that, where somebody who's not a dark personality or persistent predatory personality, you would see shame. You would see them being remorseful, that it happened in the moment. You would see that maybe they stabbed her a number of times and then they called for help. They now realise what they've done. But with him, absolutely not. In fact, he doubles down. And that is another sign that you're dealing with a psychopath. They will double down, they will respin it, they will control the narrative, and they will do everything to control everything that they can. Even when it looks like they don't have much control, like Tyrone Thompson, he still managed to get a plea deal where he made Tabitha agree that Mackenzie had the knife in her hand. Well, you might think that that's not important, but it is.
Well, Laura, the other thing that I find incredible in all of these cases, it's really, really, really hard to prove premeditation, even in, Tyrone Thompson's case, where he said to people he was going to kill her. He told her. There is obviously a really big issue. I don't know our justice systems. Is it a fact of they're just archaic? I mean, it's like we're dealing with medieval times.
Well, we are. We're dealing with very old systems, very antiquated processes. I listened very closely to the senior investigating officer in Alison Baden-Clay's case. He said he believed it was premeditated. Now, we didn't hear all the evidence for that, but a lawyer would probably say, yeah, but it's not worth going for. We're much better to focus on the murder and not get distracted. And that's what they say. But therein lies the problem, that the court doesn't hear the full range of what's gone on, and therefore they get a lesser tariff. And that's what I mean by every part of the system, who's it working for? Because often it's a lawyer who thinks, well, let's just make it clearer for the jury to understand, and let's get away from the distractions. But when it comes to risk assessment, they've now completely muddied the water, because those official documents will be maybe what the risk assessor sees. If they're a good risk assessor, they should apply for all of that information. But there are problems there because it doesn't look premeditated. Now you've got a narrative. We go back to Tyrone Thompson. Well, it's Mackenzie who had the knife in her hand and things just got carried away, in the moment. So I listen very closely to what senior investigating officers say, and that was leakage, that there was clearly evidence that there was premeditation. And I believe that case was much more about an attack on Alison, because you've also got finances that were an issue. You've got exposure and you've got a psychopath. And again, I believe him to be a psychopath who is about to be exposed. And I think that she most likely said enough enough. So you've got someone who has been compliant, who has never gone against him.
When this comes out, Laura, we'll have aired this episode that we've got is episode 6, and it's about Charles Evans. It is the worst case that I've seen, and I know there are others, and when I speak to Cheryl Moody, who does a lot on the femicide over here, she knows others, particularly, obviously, Indigenous related. You know, obviously that's a whole different kettle of fish. And I haven't gone into those cases just because there are other issues involved. Like, I'm trying to just deal with the base issues at the moment, you know what I mean, for all women. And then, you know, you can look at the extra ones that are put in place for Indigenous or multicultural. But anyway, so the issue with this one was she was identified as the perpetrator, and it still wasn't considered murder or even manslaughter. And then they downgraded it. The family had no control over that they could not. The OPP, which was the Office of the Public Prosecutor, decided to downgrade it.
Yeah, I mean, I think Victoria have some very big problems, actually, from looking at their cases and looking at the fact they don't have a coercive control law and looking at misogyny, you know, of the police and within the system. So, yes, you know, I would expect to hear those things, certainly in the UK 10, 15 years ago, less now so because of pouring sunlight onto those cases. And that's why it's so important to expose each area that doesn't work. And, you know, I look at the whole system because you have to. And so creating the coercive control law, it was to ensure more, when women came forward, the non-physical abuse, there was a legislative framework to deal with that if there wasn't something that's physical. But then it's the repercussions that sit behind that. It's what kind of sentence do they get? We know that women get far longer sentences as coercive controllers. So again, we see that sexism, we see that bias, that misogyny. So we have to keep taking apart these cases and looking at the decision making. And Victoria has come up quite a lot, actually, in cases, and me talking to professionals there. Nothing surprises me anymore, but until you put sunlight on it, and sometimes it comes down to, you know, that's the only thing where you get a reaction from the senior people to create change. But I believe categorically when you've got stalking, coercive control, there should be no plea deals made. There should be the higher threshold of the offence. There is no such thing as the ideal victim. I mean, you have Gabby Petito. So right there, you can see who's who. And I train officers, you look for the power imbalance. Who holds power? Because whoever's holding power, they're likely going to be your perpetrator. So, you know, if we can't get a case like Gabby's right, there's no hope for anybody else.
Laura turns to another case closer to home.
Kelly Wilkinson was strong, fierce, a loving mother of 3.
It was so clear that she was desperate for help, everything that was understood, and yet the officers just say she's cop shopping and do nothing to help her when she's desperate and she's a high-risk victim. And they know she's high risk.
Brian Johnston was convicted of stabbing, then setting her on fire in her Arundel home in 2021.
So my question there is, you know, particularly for Queensland Police, when they know someone's high risk and then they choose to do nothing, that's something quite different. And that's a conscious decision to make. And I don't say this lightly as somebody who worked in the Metropolitan Police and who risk assessed lots of cases. I took that role very seriously. And so I don't say it lightly that police should be held to account, but I really think it's time that they were. I really think that it's time that there are real consequences because women are going to them. It feels like just being a woman is enough for the police not to do anything. So what's it going to take to actually reverse that?
Absolutely. Well, what I would like to finish on, if it's okay, I mean, because there's so much, I guess, you know, when we get to this juncture, and it is a bit disheartening, why are leaders so reticent to do anything really worthwhile?
I'll give you my brutally honest answer. They just don't care. It's one thing for people to use the term coercive control, but it's another thing to understand actually what it is. And I think we still have a huge uphill battle at every part of the system. So then you take it through to the next step, the cases that you're covering, like Mackenzie Anderson, Alison Baden-Clay, women who were murdered. But you have 2 men who did not use, as far as we know, physical violence before the homicide event. And what we know is that those men are even more dangerous. They get favourable treatment because they present well in prison, and because when they're being risk assessed, those risk assessors are not trained in coercive control and stalking, and the parole boards are not trained in coercive control and stalking. So they struggle to understand, well, hang on, we've got this model prisoner here. He's done nothing before. This is just a one-off. So yeah, let's parole him. They haven't even identified it as a problem in prison because they are so plausible. They're incredibly manipulative. And actually our knowledge has moved far more. We're advanced to understand what coercive control is, but those risk assessors don't. The parole board doesn't.
It is kind of incredible, I think, going on this journey with just how many options are available for the perpetrator and how few are available for the victim or the victim's families. Are we making any inroads to that, do you think?
Some of it's small tweaks, some of them it's wholesale change that's going to take longer. But we know what works and we know what doesn't. It's not like you need loads of different reviews to start to figure it out. And so therefore, if you understand what needs to change and you choose not to do it, that's a conscious decision. It's just too hard. We just don't care about it enough. So you have to force them to care about it. You know, the squeaky gate gets the oil. And that's why it's so important for women to make it very clear. We make it clear how we spend money, where we spend money. We're actually very powerful. I think that there's possibly fear because there's a lot of men who use coercive control on women, and they are in our police services, they are in our law offices, even the heads who we've seen being arrested and charged. So I think that they come back with these arguments, but it's actually a very common sense approach to have. We have to be persistent and we have to use our voices and tell people, particularly for victims who don't have a voice. So I thank you for the work that you're doing, and I remain eternally optimistic that we can make inroads with the right people in power, and that's why I think we need more women in government offices, because then we would see the change, Ali. I really believe that.
One of those who is in government and prepared to appear in this podcast is Victorian Attorney General Sonya Kilkenny. Why haven't you brought in coercive control laws yet?
Well, in fact, we will be bringing in coercive control laws this year. I guess we want to make sure that the laws we're going to introduce are right and they're fit for purpose, because we've seen in the past when you do rush laws through, there can be adverse consequences for victim survivors.
They've been in place in the UK for 15 years now, though, so we have a pretty good ability to see what and what not to do.
We're working through that right now, and I think it is really important that we draw on other jurisdictions so we see what's working, what's not working, but we've got to make it fit for a Victorian model. And that is the work that we're doing right now, been engaging, we've been consulting, particularly listening to the voices of victim survivors.
How much longer, though?
And I'll be bringing those laws to the Parliament this year with a view to passing those laws this year.
Victorians are due to go to the polls at the end of November, so undoubtedly it will happen before then. I asked the Attorney General if they'll make it easier to prosecute offenders.
Well, coercive control is a pattern of behaviour, and yes, it is so much more. The very definition of coercive control is that it is so much more than physical harm, that it goes to emotional, psychological, financial. And you're right, it is important that as we call out this conduct and criminalise it in a standalone offence.
Yeah, I guess my point being is, if anything that I've learnt from the UK anyway, is that they said often, and same with New South Wales, often that the person has to plead guilty for one thing. And the other thing is there has to be violence. So is there an avenue for you to ensure in the laws that even when there's non-violence, that it can be used?
So we're working through that right now. That's part of our consultation, that we've seen now through the reforms that we've done in family violence, this understanding and realisation that no longer are we talking about physical harm. We are talking about equally about whether it is the financial, the psychological, the emotional. It is harm, and it's harm perpetuated over a sustained period, which is exactly the kind of conduct that we need to work so hard to now prevent.
The Liberal Party said that it would be like 7 years imprisonment for a course of conduct, maximum penalty. Are you going to go harder than that, or what do you know at this stage?
So we're still working through that. And again, just coming back to your statement earlier about the need to criminalise this conduct, to send that very clear message that this is wholly unacceptable. It is criminal, and those who perpetuate this kind of violence, this kind of offending, need to feel the full force of the law.
You're talking about the police. I've been through the coroner's reports, and you probably would be aware of the coroner's reports as well, where the police handling and the misidentification of perpetrators is just horrific. It's mind-blowing.
Well, on misidentification, and it is something that concerns many in the family violence sector, that and it has actually been put forward as a reason why you may not wish to criminalise coercive control, given the issues around misidentification. And it is a serious problem. We know that. It is acknowledged. And Victoria is the first jurisdiction to legislate around misidentification, to give further guidance to police and to courts about what they need to be doing when they're issuing family violence intervention orders, personal safety notices, to consider. More work needs to happen. More work needs to happen around this, and I'm really pleased that the police is working to deliver new guidelines to ensure that we reduce these rates of misidentification. And often, I think too, it goes to this very notion still of these stereotypes around women and what the sort of ideal female victim is and how she should respond in particular circumstances. But the thing is, no one responds in one particular way to trauma or to violence. And that is something we have learnt through all of the work through family violence, through the Royal Commission.
You would have noticed the Liberals, the right to ask, right to know aspect of the legislation that they wanted to bring in too, is that there's then this fear that people will rely on that. If they're not on that, then they'll think they're okay. But the public's not stupid.
And I think it's being aware, so understanding what unintended consequences might flow as well. With Clare's Law, which I'm aware of and I know is operating in other jurisdictions, you're right to identify that for some people it may be taken that if a name is not on the list, then they're fine and they're safe. And we certainly don't want women to assume that just because someone is not on a list that that person may not pose a threat or risk or danger to them. So I think all of these reforms have merit. It is about understanding the breadth and extent of the sort of unintended consequences that might flow and the means that are needed to mitigate some of those consequences as well.
Yeah, well, that's it. It's having a disclaimer. I mean, it's not an excuse not to do it though, right?
Well, I think it is important to understand the nature of the the consequences that might flow. I think, look, you'd agree too that the last thing you'd want to do is create that false sense of security for women, that if a name is not on a list, then they're safe and they're fine and there will be no harm or risk from this particular person. But I understand, and I think I understand this need to look at even perhaps a national scheme around this, about how even police in different states might talk more openly with each other about perpetrators, to be able to give an additional level of comfort to women in particular around potential future partners. And I think, again, with all of the reforms that we're doing here in Victoria, we're the first to acknowledge no system is perfect, far from it, which is why we need to continue to look at reforms. What further changes can we make?
One thing I will say is that Clare's Law in UK saves lives. So that in itself is a big thing, don't you think?
Well, I think too, in terms of deterrence, I think what is really important is that our justice system delivers the justice for women who are victims of family violence or sexual and gendered violence. So that's your first big deterrence. But the other, of course, is that even before that is the prevention work that you do, which is absolutely critical. Reform is never finished.
I know when I worked at the Portland Observer, actually, it's a southwestern Victorian town, 10,000 people was my first full-time job, and we used to print the court lists. So everyone who was in court, their names were printed, and people would ring up and not want to be on that court list. That was their main issue, not going to court, but being on that court list. So there is something to be said for naming and shaming.
Well, I'm always considering additional reforms and speaking to victim survivors about what more we can be doing to make the system even better and provide better protections for women. So I'll continue those conversations, and just by way of example, in the last couple of months, we've announced that we'll be banning good character references here in Victoria.
Convicted criminals will soon no longer be able to rely on good character references to reduce their punishments in court. The Allen government announcing it will ban the letters frequently used by lawyers to try and talk their clients out of a jail sentence. The change stems from long-standing pressure from victim advocates.
And I have to say, the response to that even surprised me. It was really overwhelming to say that, women who are in court don't want to hear about the perpetrator who has harmed them being spoken of in glowing terms and being told what a great guy they are.
But Clare's Law's not on the agenda right now.
Well, I'll continue to talk to victim survivors. I'll continue to talk to them about coercive control, about good character references, about stalking, about family violence, and we'll be talking about Clare's Law as well.
Yeah, we'll watch that space. Now, the other issue, of course, is parole. You have this coercive control, most of these perpetrators, intimate partner homicides, the whole idea of a crime of passion, all these minimising things in relation to these types of killings, which are now seen for what they are. Often these are insidious, with intent, even premeditated, because they all have the same pattern of behaviour, as you see. So now we've got a point where a lot of these perpetrators are becoming eligible for parole. One of them, Boris Ristevsky, was a manslaughter, not a murder. I spoke to the police who did that investigation. Is that something that you are looking now at, the psychology and the seriousness of these sorts of crimes are taken into account when they come up for parole?
Well, the parole board is an independent body, obviously, that assesses each prisoner who comes before them. And I don't want to step into matters that are dealt with independently. But I think what we're seeing now over, I guess, certainly since the Royal Commission into Family Violence, the responses to that to prevent family violence and violence against women and girls is a greater understanding about this kind of violence, that it is not to be diminished or seen as a lesser crime because it is, quote, domestic. And we saw that, generations ago. And I think I want to commend you also for your podcast and the work that you're doing to elevate family violence, to say this is one of the most serious and complex forms of violence that communities are facing right now. And there is a role for media to ensure that it is not diminished and seen as some lesser crime. And I'm concerned that even recently we have been starting to see that.
So you legislated when it came to police, right, to making sure that they didn't misidentify. Can't you do the same with parole to make sure that they take into account the psychopathy and if they have a personality disorder, the fact that they can't be rehabilitated?
Well, I think there are a lot of matters. So parole is a matter for the corrections minister, so not within my portfolio responsibilities. However, the parole board as an independent board is required to take into account a number of factors and circumstances, including obviously their behaviour during their period of incarceration.
The law itself, though, I guess getting away from, I can see your point about being corrective services. They would have to keep you in the loop, I suppose, because you're in that same wheelhouse of making sure that parole does look at that. Knowing the case like Ristevski, that we should be looking at making sure that these sorts of killings, these sorts of lack of remorse, for example, covering up a crime. But do you find that disturbing?
Again, it is tied with sentencing.
So we're talking about the eligibility, not that they can just be released. It's just somebody considering whether in that period that they, that they release them, regardless if they're a model prisoner. The Attorney General in Queensland will write when they have a personal feeling about something in relation to that. Is that something that you would be prepared to do?
Again, I come back to there is a need for independence in these systems.
Has there ever been something that has come past your desk and thought, wait, I'm going to write a letter?
Write a letter to the parole board?
Well, yeah, or to your correction, or to your colleague, or whatever, like what you do when you feel strongly about it.
I think what's really important, when you're talking about parole decisions, and again, I come back to the need for that independence for the parole board to make those decisions on an assessment of the individual before them, but really important that they speak with the family of the victim, they speak with the victim as well to understand.
Well, if they're alive.
So that, again, is a matter for the parole board. I think, look, my position as Attorney General is to ensure that we've got a justice system that meets the needs of everyone in the community. And I have to say, from having spoken with victim survivors, the system hasn't worked for women. It has failed women. It is far from perfect for women. And we need to continue to listen to the voices of women to say, what more do we need to be doing to fix this justice system? And that is the work that drives me every day.
It's funny you should say that, though, because one of the things is that I've always got, so I imagine you would have too, from families, if there was one thing that in Victoria seemed to be the biggest issue, and that's the downgrading of charges from murder to, in Alicia Little's case, dangerous driving causing death. They weren't consulted at all. until after the fact, and then it was just to appease them. I've got half a dozen more. This is a massive issue in Victoria.
It's my understanding, Alison, that the OPP is required as part of the Charter of Victims to consult with families as they work through this process. And it's my understanding that that would have and should have occurred in all cases as part of the Victims' Charter.
Do you mean consultation where they actually have input, or that they just tell them what they're doing?
Well, it would be consultation to describe the process and part of the reasoning for why particular steps might be taken. And so it's difficult for me. I can't speak to individual cases.
If you're going to downgrade something from murder, because that's a serious thing, like someone's died. So if you're going to do that, like it would stand to reason that you at least talk to the family, get their input before you make a decision. Would you want to ensure that?
Again, Alison, it's certainly my understanding that the OPP will work closely with families, particularly where there's been a death. And under the Victims' Charter, they're actually obligated to do that, to consult with families on plea offers and obviously take the family's views into account. So that should be the position, that should be what is taking place.
So are you saying that they're misinforming, or is it something that you'd look into?
Well, no, I'm saying that under the Victims' Charter there's an obligation, and there is a commissioner with whom victims can communicate to discuss their concerns if they feel that they haven't been adequately consulted in these matters. And I understand it. I understand that concern from families. I think the justice system can be a very isolating and traumatic experience for not just victims, but then the families of victims who need to navigate it. And it is important that they are taken through, that they are supported, that they're consulted, where there's an obligation to consult and to discuss matters like a plea bargain.
But if they don't, is it something that you would then say, look, or at least have somebody or whoever it is who's in charge then say, look, this needs to be adhered to?
Well, if that is not being adhered to, if those steps are not being taken, then yes, we need to review that, absolutely review that. As I said, it's an obligation under the Charter for the OPP to consult with families and to take them through that process, to also listen to the views of families around those matters. It is a very difficult situation, though, of course, because the OPP will have access to a lot more information than many of us will have, that goes to the evidence, the risk in the cases. So they'll have that information.
They're never always going to get it right. People are going to make mistakes. People are human. And even in the court system, the judges, that happens all the time. So even the language that is used in court, we need to upgrade, don't you think?
Well, I know that the judges do a lot of training around appropriate categorisation, gender. A lot of work has taken place over the last decades around this. I think what you're referring to is something perhaps we have seen in the past, and occasionally we may see signs of that emerge as well.
But like all justice systems in Australia, we're looking at one that's geared towards perpetrators. So I guess the whole issue is that there are a lot of avenues for perpetrators, but not for victims.
I guess you start with the fundamental principle that everyone is innocent until proven guilty. But what we need to make sure of is that the system adequately responds to the needs of victim survivors, that it's not tilting the system in such a way that it's actually disadvantaging victim survivors. We have to continue to make reforms that make our system more accessible to those women who come forward to report crimes, but also to use the law to act as prevention, to deter future perpetrators from committing these kinds of violent acts, whether they're physically violent or whether they're violent psychologically or emotionally or financially.
I finished up asking the AG what advice she gives to her children when navigating today's society.
And that's such a good question, and I think there's so many things that are feeding our young people these days that it's so important to ensure that they understand they need to challenge everything. And apart from us, of course, the parent, the mum. So I always say to my son, there's one source of truth, and that's me. And then for everything else, you need to question it and challenge it and analyze it. Do not take everything at face value, because social media obviously is the best and worst of everything at the moment. And I think it's really important that kids are taught that they do need to challenge what they see through social media. They do need, through school, and here in Victoria, obviously we've introduced respectful relationships, and that's all about trying to teach our young people that relationships are all about respect. They are all about respect. They're about equality, about fairness, and about the way we treat each other. And it is about ensuring that through whether it's your social circles, whether it's through school, but that sort of fundamental principle around kindness. And if you keep something simple for kids, I think it's something they can grasp onto. But I think it is so vital for young people in particular that with access to information and therefore access to misinformation never greater than ever before, that they need to challenge what they read, what they see, and what they hear, but always coming back to kindness and respect.
As Laura Richards mentioned, it's that kindness and respect often lacking in the legal system. Victims can be dehumanised, referred to as the deceased rather than their names, while killers are treated with dignity.
I was seeing so many clients who were absolutely traumatised through the counselling and the psychological support.
Naomi Pearce is the founder and driving force behind TFA Legal, Australia's pioneering trauma-informed law firm providing expert legal advocacy and compassionate wellbeing support to coercive control survivors.
It became just very obvious to me that no matter what you do from a psychological perspective, they also need to have some of their situations actually resolved, which is why I thought we needed advocacy and legal.
She also assists with complex family breakdowns, drawing on her counselling and mental health background. Naomi bridges justice and emotional recovery.
There's a few different types of perpetrators, and because I studied criminology as well as psychology, so it was very interesting to me to look at things that we could do to stop the perpetration of such crime. And so that's sort of what really kicked it off.
Just before you go on, when you say there are different sorts of perpetrators, can you explain what the different sorts are?
Yeah, like for example, you've got like psychopaths, for example, that are just unstoppable, and you know there's not much research for rehabilitation in that situation. Then you've got people who have impulse control problems, which can be brought about by mental health issues, personality issues, and also having been a victim of incredible violence or abuse themselves. And from that perspective, I was very interested to see, you know, what sort of options could, you know, we have rehabilitation situations. There's also drug and alcohol, it's a fueler, and we have drug and alcohol rehab centres, but I feel it could be quite good to develop some rehab specific centres for violent crimes within the home, you know, family violence, because there can be, you know, death by, you know, with this impulse control issue, especially if there's drugs, alcohol, or mental health or personality issues, it can be almost accidental. And it's catastrophic and very easy for it to happen. And you sort of think there might be something that we can really do to, because it's so common. Just incarceration isn't necessarily going to fix that particular type of perpetrator.
It's interesting you say accidental, because all of the experts I've spoken to recently have said the premeditation is harder to prove, but the intent is there in the sense that it takes a lot to kill someone, right?
It does. But sometimes if people are, say, psychotic, for example, like say they're having a psychotic break, and there's a mental health issue or there's a drug and alcohol thing. I'm not saying this is like an excuse at all, but people can do something crazy like drive at an oncoming, you know, car, or push someone and next minute they're over a balcony. And there is a lot of intent, but I feel like it's important to look at the different types of perpetrators, like psychopaths, sociopaths, intent, 100%.
Well, they can't change either. They're very hard to rehabilitate.
That's right.
Yep.
And one of the problems is we do have a drug and alcohol issue that's out of control, and there's also a problem with access to really solid mental health for a lot of people. And then you get, you know, psychotic breaks, and that's when you can have, you know, someone can go, you know, there's a lot of there can be a lot of crimes, particularly homicide, that could be possibly prevented if we had some really good structures here, like a very tailored rehab. Possibly, that's just one idea. But.
Yeah, but how would you? Who would be in that? Because obviously not the psychopaths in that. I mean, what predetermining factors?
There'd have to be some very significant testing around who would be able to go into a facility such as that, because there'd be no, as you say, there's like no point if people are, you know, in that, like a psychopath, sociopath, or, you know, but
personality disorders generally.
Exactly. And also the personality disorders, you know, they can vary a lot as well.
Naomi has considerable experience in family court and recalls one situation which made her realise how out of touch it was.
Obviously I'm not a legal expert, but I had some experience with someone being, you know, attempted to be run over after a family court hearing, and they were almost hit. So the family court hearing had concluded, and the mother was showing psychiatric reports and a lot of medical reports to show that the father was not able to be safe with the child. Anyway, so all of that was shown, and the family court said, well, look, that could be just the mother, you know, sort of like making it up, so to speak, you know, which is often an accusation when mothers present those things. And I'm sure it doesn't happen all the time, but it does happen quite a bit. And you know, particularly, this is a long time ago, so the courts were less informed as well. Anyway, so then the mother walks out, keys were locked in the car, had to call NRMA. NRMA were helping her get in the car. Then the father, with a carload of people, tried to swerve and hit the mother. And whether it be, just to scare her or whatever, but the NRMA was next to the mother, so the NRMA guy was almost hit as well. So there was I think it's called in Canberra an AVO, or a violence order at the time, so that was a breach, so that person was arrested. And then there was a bail hearing. I think that might have been the next day, but essentially the same evidence that was shown in the family court to show the state of mind of the father of this child was presented to show the danger and the need for him to be denied bail in the other court, which I think was the magistrate's court, and he was denied bail. But in the family court, he was given unsupervised contact with a 3-year-old, and in the magistrate's court, he was denied bail.
While there's been some advancements since, it's another branch of the legal system which needs to catch up. She says if violence is involved, it shouldn't be in the family court at all.
I really do think if we just had a blanket violence is violence, and if you're just having a marriage breakup and you're just you're having a bit of an argument over where the children should live because maybe you want one home, not 2 homes, because you're worried about stability and there's no violence, you could do that in mediation. And anything with a hint of violence, I believe, needs to be heard in a criminal court.
And says part of the problem is the expertise of those making the decisions.
For example, an independent children's lawyer is not a psychologist or anything, and they are interviewing children that where there's alleged abuse. Say there's a custody battle, people want parental rights stopped or whatever, and they'll appoint an independent children's lawyer or to make a recommendation to the court. Now they're lawyers, and lawyers are wonderful people and they're great at the law, but they're not necessarily able to interpret a child, understand whether there really is abuse, because a child typically, when they're very badly abused, won't necessarily want to talk about it. And there's a big problem with those people being the experts to report to the court about what should go on, because they're lawyers. It'd be like a psychologist recommending a legal thing. Do you know what I mean? So there's a few problems there, and I feel that with the family court, there's a little bit, and it probably, I can't say it necessarily is coming from all people on the bench, but there's a little bit of sort of mother shaming, and in some circumstances the children, like the mother is traditionally a nurturer. I'm sure there's people who aren't such, etc. But if the children go to the mother, or if they go to the father, or whoever they're going to go to one of the parents to report something, because that's the trust. So if a mother has to bring something like that up, it shouldn't be about, do we believe her, do we not believe her, is she lying, It should be, let's just have a look at this. Let's investigate. Let's not get a lawyer to investigate. Let's send them to a forensic psychologist who's trained, or a paediatric psychologist who's trained to understand, and allow them to make a recommendation to the court. The main point is, if they're violent, the family court is really not in a position to decide what is going to be potentially homicidal and what is simply, people being emotionally fueled.
And so if what you're saying is if we have any hint of violence, if violence is an issue, then then those consent issues should be then moved to magistrates?
Yeah, so supervision's not always by consent. Sometimes the court will invoke supervision. And I just think if there's an allegation of serious violence, as in there's actual evidence and there's, because people, I'm confident that, within all of it, you could have people, unfortunately making it up, but that would be a minority, I would suggest. But I think if there's any violence, there needs to be, a paediatric psychologist or forensic psychologist brought in, and in regard to how that's handled, we need to have a different court. My suggestion is that there's a totally different court structure. So it couldn't be just transferred to the magistrates court now, because that's not set up to deal with those matters either. But maybe we could have a court structure where there's a magistrate type of court that deals with how to, because seeing both biological parents is part of a child's identity, and however, it's not always the best.
Yeah, I can only imagine how hard it is for everyone involved, but particularly those who are having to navigate it. Now, tell me about your organisation and how, obviously there was a need there that you found when you started it up, and where you're at now, like where does it exist?
Okay, so it started up in Melbourne, and family law is like a national sort of law, so we operate all over the place. And now what we're trying to do is change the structure so we have more boots on the ground in each state, and so that we can really help people. Like, for example, it's very hard for people, not only dangerous when they first leave, but it's very hard for them to disconnect from that abuse, particularly if it's coercive control and there's no physical violence. It's hard. As they start remembering, they can sometimes feel like, oh, it wasn't that bad, and next minute it can take, a bit like giving up smoking, it can take quite a few times for someone to really separate themselves from that situation.
It's all. So how long does it take to extract yourself from a relationship like that? Do you know? Or
it really depends on the type of violence that's going on, and it depends on how long the victim's been with the perpetrator. Because say they're vulnerable before they get into the relationship, and then they get into the relationship, and it's almost like they're whittled away. So their norm is very different to the average norm. Like, I've heard victims say, oh, look, he's really, like, he's so much different now, so much different. You go, oh, okay, so tell me about what happened last night. Oh, we watched TV, it was great, it was awesome. We just watched TV, and you sort of think, so that's the highlight of that person. So the bar gets so low, so it takes, you know what I mean? So you're losing, like, the loss of perspective is just so hard.
But acknowledges it's not the only place double standards exist.
Sometimes as women, I think we can be not as kind to other women. Like, I was once listening, I was in a social situation, I think I might have been in a pub or something, and I was listening to a whole bunch of people talking, and there was a woman saying, oh my God, she was talking about a single father. Okay, so, and this wasn't to do with violence, but it was just an attitudinal thing that I thought was really interesting. And she was saying, he has those kids every fortnight. It's just like, and like, she's a single mum, and she gets all this maintenance, and he's just, he does everything for them every fortnight. He takes them here and there, and it was really like, I felt like turning around and going, you mean his own children? Like, and you sort of think, there's a real society, like, there's a lot of, like, we really need to let our young mothers and everything know that it's okay. Like, if you have to separate because things are like coercive controls going on or something, that's okay. You don't have to be together. Kids are happy. If they've got two families, they're happy.
Yeah.
Or, you know.
Yeah, we should definitely be kinder to other women. Just quickly before we go, why did you want to do it? Why did you think that you could do this? Because it is a massive undertaking.
Because I was a victim of it.
I'm sorry to hear that.
So many moons ago, a long time ago, I experienced it, and obviously
you don't have to go into it, but I just want to the context of what you learned.
Yeah. So what I learned was the system can be weaponised. So in regard to coercive control, that if you are somebody who's experienced, say, like a psychopath or somebody that's really really horrific, they can just keep putting on applications and applications and applications and applications, and then if you're a working professional, you have to defend all the, because anyone can put on an application, and then you've got to defend it. So it's a way of actually breaking you, and that's happening to a lot of people, and that is still happening. And that's one of the reasons that, so over the years, and I've studied like extensively now and really made this a focus. It was something that I always wanted to, I wanted to see if I could make it different for other people, new generation, all that sort of stuff. And I wanted to develop something where it couldn't be weaponised. So what we're doing at TFA Legal is we have fixed prices, which means at each stage people know how much it's going to be. We don't charge for any of the psychological counselling or support that they receive at all. And we take calls after hours for that part of it. And we make sure that people don't have to come into the office, like some of the little small children and things. And we make sure that the lawyers have also the ability to debrief. Obviously we have an independent EAP system, but we also work with the lawyers to explain, because even things like the wording of an order can change someone's life. Like, for example, say it's a situation where there's parental rights being given totally to the mother because the father's a psychopath. If the order's written, a psychopath will often want a connection, so they will often ask the court to make an order that she's in charge of, say, provision of newsletters to that person. Okay, now that sounds like nothing, but it's really common, and what that does is it allows the psychopath to have a reason to bring it back to court, because hang on a sec, the newsletter hasn't arrived, and it keeps the connection going. So it's quite psychologically damaging. And then if somebody breaches an order, it's actually a jailable offence. So technically, say the newsletter didn't arrive, she could be like, there could be a court application made for her imprisonment. That's how stupid it is. Anyway, so that we didn't, so that was a minor thing that made a major difference to that woman's life.
Next week, we know the problem, but what's the solution?
The thing is, coercive control causes more murders than practically anything. So, it's the biggest homicide category for women. The best deterrent to crime is not the length of the sentence you get, but the surety that you will be held to account.
And why it's so easy to fall victim.
We've all been conditioned to believe that kind of romance is something really aspirational.
And so hard to escape.
He got angry about that, but then went back to the love bombing behaviour. So it's this kind of confusing situation where You want that validation from them, and so you want things to go back to the way they were before. So you will kind of brush some of that behaviour under the carpet, and then it escalates.
If you would like to share any information on the cases we've mentioned or discuss a different intimate partner homicide, please contact us. Just email us at kissandkill@7.com.au or visit our website 7news.com.au/kissandkill. Check out our show notes for information about everyone you've heard in today's episode, but also links to various domestic and family violence charities which are making enormous headway in this space. If you're on Facebook or Instagram, you can follow us to see photos and updates relevant to the series. And if you like what you're hearing, don't forget to subscribe. Please rate and review our series. It helps new listeners find us. Presenter and executive producer, Alison Sandy. Sound design, Mark Wright. Assistant producer and video editor, Cassie Woodward. Graphics, Jason Blanford. Video editor, Carmen Bensley. Special thanks to Dr. Claire Ferguson and Sherelle Moody. This is a 7 News production.